We can take few questions from the audience if you had some. I will start with one for both of you. It's my experience being an international lawyer is almost in every places in the world, the judges have an interpretation power, if I may say, with this personalization law program, I would say, isn't it a risk that the judge would see the interpretation power reduce because the principle would not be the principle? The data screening would have done the job, and then the judge would have no room for interpretation.
No more than 2 minutes to respond also to some of those questions. I do it very quickly because I want to hear your questions. But so first of all, thank you very much for these excellent comments, and of course very thoughtful. And we will certainly think more of them. But so very quick response. First thing is about equality. So depending what do you mean by equality. So take the negligence example. So suppose we have 2 potential injurers, right? Now, under current law, they have the same standard of care. Everything else is equal, they have the same standard of care. Now, suppose that for one of them, which is very unskillful, it's really a huge burden to meet the standard of care. While for the other one, it's very easy because he's very, very skillful. This is the law. Is it equal or not? I doubt. With personalization, it might be. So equality might be advanced here. It doesn't mean that you might not be right in other contexts, but we should be very sensitive about this equality. The second point that you have mentioned, Florence, is about values. I completely agree. Right. Sometimes we have certainly mandatory rules, but even default rules, which are kind of, they have some value in it. It's not just about saving transaction costs, what we sometimes call in economics terms. It's more than that, right? So, for example, take the intestacy example, the inheritance law. You could imagine that in some countries, I'm not sure, but is it true that in French there is a kind of a mandatory rule that says that at least a certain percentage of the estate should go to the children? Absolutely. Yeah, so I'm proud of knowing that, but so I'm right. Okay, good. Now, so suppose, I think it's 1/3. Am I right? Like at least 1/3? Anyway, I shouldn't push my luck. And but suppose we think that the default rule is not just a matter of, so there is some values here. So imagine that there is a default rule in a jurisdiction in which you can opt out and allocate the estate any way you like. But still, there might be a value that half would go to the children. Again, people might opt out and change it, but still there is a value that the default rule says so. Fine with me. As long as the wills of the parties has some relevance, more than 0, then you can think of personalization. Right? Suppose there is an issue of values and also the parties' preferences. So you could think that the values should be 50% in general, but also the wills of the parties or the preference of the parties matter. So take both into account. As long as the parties' wills or the parties' desires is relevant, personalization should matter even if values matter. If it's only values, and the parties' preferences are completely irrelevant, then personalization is irrelevant too. The third point is maybe the last one, because I don't want to spend privacy, of course, it's an issue. We can maybe discuss it later, about certainty and uncertainty. I think this is a very good point, and let me respond briefly. Think again about negligence law. So suppose there is a standard rule, a rule saying that you should drive your car as the reasonable person do. Suppose I drive a car here in Paris. What exactly do I know about the reasonable person in Paris? I think it's much easier for me to do what is reasonable to me. I think it would be much more informative to me to know what is reasonable for me knowing my own skills, knowing the inherent risks that I create with my driving. There is a kind of let's say, how to say it, like we pretend as thinking that if there is a uniform rule, everybody knows the uniform rule, and so on and so forth. But this is wrong, because especially in negligence, you need so much information to know how the reasonable person would drive her car. You know much more about yourself. So I think this is just like starting to responding to this question. But of course, sometimes, of course, that you might be right. So I think your question is about the role of judges, right? So suppose that in a future world, there would be algorithms, and in contractual cases, suppose that courts would not have to interpret anymore because everything would be known. Right, so that probably could be one of the consequences. The question whether it's bad or good, I don't say that it's necessarily good. It could be bad or good. It's a different question. I think that in a way it might be maybe more accurate in certain areas, right? So if the judge tried to interpret what exactly the party wanted to do, what were their preferences when they entered into the contract, what was their subjective intention, and so on, maybe it would be just more accurate if they have more solid data, right, derived from big data, or have an algorithm to do it much more accurately.
Thank you very much. Any question from the audience? We are running late a little, but I think we can take 2 questions. 2, 3, yeah, 2, 3. Yeah.
I have a question whether the whole idea of personalization of law is not unnecessarily provocative, because I think it's not so revolutionary as it looks like. The question is it sounds like it would be then the law different for different persons. But I think this is not what you're meaning. It's more about a personalized application of a general law. And you use information from the context and from each person in the application of the law. But this is what we are already doing all the time. So from competition laws, I'm a competition policy person, we have the old debate in the US about per se rules versus rule of reason. And the rule of reason, which is 100 years old in US antitrust law, is really about taking into account specific context in which firms are really, for example, applying a certain business practice. And it depends on the effects of this context, whether this business practice is then allowed or not. And this means that different firms, so one firm might be allowed to do something, and the other firm are not allowed to do the same thing. But you need information about this. That's exactly what the more economic approach was about in European competition policy. And so in that respect, big data only gives us more information for doing exactly this. Is this the right interpretation, or do I see it? Is this more revolutionary what you're doing?
Yeah.
I think you're very right. Yeah, absolutely.
Yeah, I think that I agree to, well, maybe 99% of what you have said, well, just to be cautious and not to agree completely with what you have said. Yeah, I think this is a possible way to put it. But again, of course, that if personalization is done in the way that we suggest, the law would look different. So, think again with the example I started with. As far as I know, there is no any jurisdiction in the world in which, well, I don't know all the jurisdictions, of course, but I would guess that there are no jurisdictions in the world in which intestacy law would really make a difference according to the identity, the characteristics, and so on of it. So you could say, in a broad sense, that once we have more information, so the concept of the law is still the same, and it's a way to implement it differently. I completely agree with that, and so another way to put it, it's about, as you said, it's about information. Once we didn't have so much information, now we start having a lot of information, so personalization might be feasible as long it's not a matter of principle not to personalize and just a matter of feasibility, then why not to personalize if we can? Again, I understand that there should be some normative issues, and then we should take it into account.
Absolutely. There are two questions, and then we have to break. So one's here. Yeah.
So thank you for this presentation. I understand it's in a very liberal context. So could you comment about your view of the Chinese social scoring, which is personalization in a very different context?
Could you say a bit more? In what way personalized Chinese law?
They use data about behavioral patterns and comments from other people to give rights or delete rights from individuals.
Yeah, I think it, more generally, let me try in a bit different way, because I don't want to speak about a legal system that I don't really know, but I hope that it will be kind of a response. I think when it's about people's like constitutional rights, right, we should be very, very careful here. It's not impossible to think about personalization of constitutional law, right? Again, I'm not sure that this is something we want to do, but imagine a legal system that allocate constitutional rights according to people's preferences, right? Think about it as a kind of a limited budget. Suppose that your country is willing to invest X amount of money, X dollars or euros or whatever, to protect your constitutional rights. One way to do it, uniform across the board. Everybody would have exactly the same level of constitutional rights. Now, but suppose there are some people who care much about free speech, and some others that care much about privacy, and maybe others that care about, you name it, any kind of freedom. So maybe make different bundles of constitutional rights to people, and maybe everybody would be better off. Of course, this is strange to you and even to me, and I'm sure to Omri too. But so there are normative issues here that we understand. It's not. It doesn't mean that I think it's a kind of thought-provoking. Right? That's maybe in some spheres it makes some sense. Maybe in certain areas it makes more sense than in others. But I agree that there are limits to what we can do with personalization.
Thank you. One last question on the front, I think.
Yes, thank you very much. I'm just a bit concerned about the discussion. So as far as I understand, we are not talking about the personalization of the application of the law, but the personalization of the law itself. So we have 500 years of history whereby we tried to objectivize the law in order to avoid some kind of arbitrary power. So now if we are talking about data, we can have very granular data. We can segment the population ad nauseam based on sex, age, social profile, and so on. If we are going that way, personalizing the law itself, the rule, who is making the decision? What is the limit in terms of segmentation? And basically based on what?
Yeah, sure. Okay, I'll do it briefly. Segmentation of the law, it's an issue, right? So even, from a legal perspective, maybe think about the role of precedent, right? So the court decides a certain issue, and in those countries in which there is, stare decisis, right, that it applies also to other cases, with personalization, maybe you cannot use it anymore, and that's also part of segmentation of the law. I'm not sure that this is good enough reason not to do it, but certainly might have, this is the kind of additional cost that we might have. But about arbitrariness and so on, again, it's the question about how the algorithm is good enough, right? That's, I think, the point that also we have heard in the previous lecture. So, right, algorithms might be terrible sometimes, and then I believe that they should be improved, and at the end, I'm not sure whether it's more or less arbitrary than the decision of a court or a judge, right? Think about it. We are, I think, all lawyers, or most of us here, I believe, lawyers. Am I right or not?
Yeah,
okay,
right.
Most of us are lawyers. So we got used to it. But think about this very strange idea for any outsider, that two people have a dispute among themselves about anything, and then sometimes in many jurisdictions, there are jury systems, but think about those legal systems, like in Israel, and I think also here, that sometimes one judge, one person after all, would have to decide who is right and who is wrong. I'm not sure that this is necessarily better than having a very sophisticated algorithm, right? Or think about criminal law. Suppose you are accused of a kind of an offense. And suppose there is a data saying that even if you are innocent, there is 10% chances that you would go to jail because the judge might be wrong. Suppose now that an algorithm, the error of mistake is only 1%. 1% versus 10%. Still, it's a logarithm, there is a transparency issue, we don't exactly know what happened. 1% here, or a judge that would argue and give, although I know that in French, court decisions, are very short, I know, but in other places they are longer. I'm not sure that I prefer the judge under those circumstances. Do you? Okay, so it's a rhetoric question.
So I think we would need a coffee and a break to think about that. Thank you very much.